My name is Miriam Edel, and I'm the Judith London Events Director of the Tam Institute for Jewish Studies. And it is my pleasure to welcome all of you to tonight's keynote for a symposium that we've been holding today and will continue tomorrow morning. I'll say more about that in a moment, on the post-Dobbs America through a Jewish lens. Tonight, we're gathered for the Rothschild Lecture. We're going to hear more about Rabbi Rothschild. We normally are able to welcome Janice Blumberg, the widow of Rabbi Rothschild, for whom the lecture is named. She is unfortunately not able to be with us tonight, but we are thinking of her. We have many co-sponsors that made this event possible. And I would like to thank and recognize the Center for Ethics, the Center for the Study of Law and Religion, the Center for Women at Emory, the Department of History, Political Science, Religion, Women, Gender, and Sexuality Studies, the Fox Center for Humanistic Inquiry, the Hightower Fund, and the Jewish Chaplaincy Program of the Office of Spiritual and Religious Life. Tomorrow morning, please come join us in the Emory Student Center Multipurpose Room N106 at 10 o'clock for a roundtable discussion called Post-Dobbs Georgia Through a Jewish Lens. This will be a roundtable discussion of local Emory and Georgia-based activists, practitioners, and policymakers, including Representative Esther Panich from the Georgia House of Representatives, Dr. Sharon Rabinovitz, head of Emory Student Health Services, Rabbi Melissa Spolton Gutierrez, a community educator, and moderated by Dr. Paul Wolpe from our Center for Ethics. Now it is my pleasure to quickly introduce and hand things over to my partner in crime and the co-convener of this symposium, Kate Rosenblatt, with Jay and Leslie Cohen, Assistant Professor of Religion and Jewish Studies. But before I do, I just want to say that when you're going to do a big lecture and also a symposium, there are two ways that you can manage that. One is that you can separate them in time and let everyone plan and attend and recover. And the other way is that you can smush everything together and say, we're going to have an economy of scale. It's going to be great. It's going to be so efficient. Well, we went with the latter. I hope it was efficient. I know it's been great. I know that the energy has been incredible. And the reason for that is the hard work of our staff. So before Dr. Rosenblatt comes up, I would ask you to join me in a warm round of applause and recognition for the Executive Director of the Tam Institute, Paul Entis, for our events and communications guru, Brent Buckley, and also our gratitude to Mallory Mibab and Rebecca Strug, who made all of these events happen so smoothly. Thank you.
Thank you all for coming. It's so nice to see so many of you here. Welcome to the annual Jacob M. Rothschild lecture. Jacob Rothschild was the rabbi of the Hebrew Benevolent congregation, colloquially known as the Temple, and is remembered as a force in the local civil rights movement and a friend and supporter of Dr. Martin Luther King. In the 1950s and 1960s, Rothschild led local white clergy to support school desegregation. He organized Atlanta's first interracial dinner to honor MLK's awarding of the Nobel Peace Prize. And he gained national attention, of course, for his courageous moral leadership when the temple was bombed in 1958 by white supremacists who viewed him as a threat. And so I am delighted to introduce our speaker for tonight, Professor Rachel Kranson, whose work, I think, fits so nicely into the legacy of Rabbi Rothschild's life. Professor Kranson is the Director of Jewish Studies and Associate Professor of Religion at the University of Pittsburgh. She's a historian of American Jews and gender, and in the late 20th century. And she is the co-author of A Jewish Feminine Mystique, Jewish Women in Post-War America, and is the author of Ambivalent Embrace, Jewish Upward Mobility in Post-War America. In a moment of political turmoil in the aftermath of the Dobbs decision, I'm thrilled to be able to introduce her new work on the history of abortion activism and activism in support of reproductive rights that was undertaken by Jewish women across the second half of the 20th century. And so I'm just so thrilled to have you and to welcome her to the lectern and for us to hear about her fascinating new work.
Thank you for the introduction. Thank you so much to Professor Rosenblatt, Professor Udell for inviting me here. I am really honored and humbled. Thank you so much to all of the staff who made this so easy and seamless. I also want, I'm not gonna go through the history of Rabbi Jacob Rothschild, but only to repeat that he just left a legacy of moral courage that's been inspiring for so many American Jews. And in fact, when he comes up in talks that I give locally in Pittsburgh, where I'm from, someone in the audience will always raise their hand and say, Rabbi Rothschild was born and raised right here in Pittsburgh. So I just, which he was. So I just want you all to know that, you know, yes, I mean, correctly, Atlanta claims him, but, you know, privately, we in Pittsburgh claim him as well. And I really, I mean, in all seriousness, I really am beyond honored to honor his memory this evening. Okay. And finally, I also just want to welcome everyone who's here and taking the time to learn more about the history of Jews and the politics of abortion. This is important knowledge for all of us to have, especially now when access to legal and safe abortion is restricted or banned in so many American states, although maybe less, maybe fewer as of, thank you, Ohio. So again, my biggest honor tonight is to be able to engage in this conversation with all of you. So this evening, I am going to share just a bit of my research from Religious Misconceptions, which is the tentative title of a book that I am currently writing about the history of American Jews and the politics of abortion. My research begins in 1973, the year that the Roe v. Wade decision guaranteed pregnant women a constitutional right to an abortion in the United States. And most of my work focuses on those American Jews who tried to protect this constitutional right to an abortion during the Roe era. Although, of course, when I started my research, I did not know that it was going to be the Roe era. I thought I was researching this work in the decades after Roe. So again, my work, I've had to rethink my work in certain ways because of the current political moment. And this is precisely why, to my mind, this is a history that has some urgency to it, because I'm sure, as you are all aware, our current moment is not necessarily, doesn't necessarily always feel like a hopeful one for those of us who care about reproductive freedom. But even though, generally speaking, we may be living through a moment of repression in terms of reproductive freedom, I find it heartening to know that there have been many American Jews who have been fighting for reproductive access for a very long time. And part of the reason that I'm so invested in this history is because I think that some of the legal arguments that Jews made to defend abortion in the late 20th century were good ones, at least worth thinking about in the current moment. And again, for a number of reasons which I will later share, these arguments are well worth revisiting and thinking through as we continue to fight for reproductive freedom today. Okay, I'm also going to say, this is turning out to be a very long introduction, but I'm also going to say that assume for the purposes of this presentation that most of you don't know all that much about Jewish law on abortion. And I'm also going to assume that most of you don't know all that much about the history of reproductive law or much about First Amendment law. So my apologies in advance to those of you who may happen to know a lot about any or all of these topics. I'm not going to assume any baseline of knowledge. I just want to make sure that I'm bringing you all with me. Okay, so with that, let's begin with an open letter that the American Jewish Congress published in the New York Times in the winter of 1989. And as you can see, this letter asked the American public, do you know that abortion can be a religious requirement? Not just permitted, but required. Some religious traditions, this letter continued, demand that people consider the needs of people who are already born before worrying about the unborn. And some religious communities, this letter also insisted, believe that the life of a pregnant woman takes precedence over the life of her fetus. With this letter, the American Jewish Congress was trying to let the American public know that some deeply religious people considered abortion to be a moral and ethical act, and sometimes even a religious obligation. Making this point seemed particularly urgent in the winter of 1989. That winter, the Supreme Court was considering the Webster versus Reproductive Health Services case and deliberating on whether or not to uphold Missouri state laws that restricted publicly funded institutions from providing abortion services. Many American Jews felt strongly that these restrictive laws undermined Jewish religious traditions that supported, and again, sometimes even demanded, access to abortion. The organization that published this letter, the American Jewish Congress, at the time was an influential public advocacy organization that protected the political and legal interests of liberal American Jews. In the 1970s, 80s, and 90s, it was one of many liberal Jewish organizations that advocated for abortion to be legal and accessible at a time when anti-abortion lawmakers were steadily chipping away at abortion rights and abortion access by creating legal hurdles that pregnant people needed to get through before they could access abortion care. Throughout the late 20th century, liberal Jewish lawyers, activists, and clergy consistently advanced the idea that abortion rights were protected by the Constitution's First Amendment, or that they ought to be protected by the Constitution's First Amendment, and that American women ought to have a religious right to terminate a pregnancy. Unfortunately, it was often hard to get lawmakers, judges, or the media, frankly, to take this argument seriously. And this was because the late 1970s saw the rise of what became known as the religious right, which is a political coalition made up of primarily conservative Christians, mostly evangelical Protestants, and conservative Catholic activists. And they promoted the popular misconception that all religious Americans believed that abortion was akin to murder, and that anyone in favor of abortion access was necessarily secular or anti-religious. This framing of the abortion debate made it difficult for any religious Americans, including Jewish Americans, to articulate a position in favor of legal abortion care that was based on deeply felt religious convictions. Another common political strategy of the Christian right at the time and now, which made things particularly difficult for liberal Jewish abortion advocates, was that they claimed to be defending Judeo-Christian values as they publicly opposed feminism, LGBTQ rights, and reproductive autonomy. This rhetoric of Judeo-Christian values did and still does a lot of work for the Christian right. It makes their opposition to abortion access seem like a universal religious point of view that transcends Christianity. even though in actuality it is only a very particular conservative subset of American Christians who actually believe that abortion is incompatible with a religious point of view. Needless to say, the 83% of American Jews who believe that abortion access ought to be legal see nothing very Judeo about the Judeo-Christian values that were and are touted by anti-abortion activists. Jewish traditions about the origin of life and the ethics of terminating a pregnancy differ considerably from those of the conservative Christian activists who claim to speak on their behalf. And American Jews then as now often struggle to let the American courts and the American public and American lawmakers know that Jewish values and Christian values are not interchangeable on the subject of abortion. So in my presentation this evening, I'm going to discuss the ways that the lawyers of the American Jewish Congress harnessed the religious freedom clauses of the First Amendment to try to protect abortion rights. This approach was very different from that of secular pro-choice litigators or feminist pro-choice litigators. Most pro-choice lawyers tended to base their defense of abortion rights on the implied right to privacy or the Equal Protection Clause found in the 14th Amendment of the Constitution. But in the late 20th century, American Jewish lawyers were instrumental in formulating a First Amendment defense for abortion rights. But before I get to that legal history, I want to give a really brief overview on how classical Jewish sources conceptualize abortion. I'm not doing this because I am an expert in Jewish law, halakha, I am not. And I'm not even doing this because the way that I'm, we say learning out Jewish law here is the only way that one could possibly learn out Jewish law on abortion. I'm doing it, I'm giving this particular overview because these are the sources and these are the materials that the lawyers of the American Jewish Congress and other liberal Jewish lawyers drew upon when in the courts when they were trying to explain Jewish positions on abortion. Okay. One thing that will be absolutely clear to you after hearing about these classical sources, though, is that there's absolutely no single Judeo-Christian attitude towards abortion. Because even those Jewish groups that are fairly restrictive on when an abortion might be permitted come to that conclusion through a very different path than Christians do. And I should also say, there is no one Christian view on abortion either. So if there's no one Christian view on abortion, there certainly is no one Judeo-Christian perspective on abortion. These are highly diverse and complicated groups of thought. Okay. So the oldest source we have regarding abortion comes from the Hebrew Bible. The book of Exodus talks about a case of accidental abortion. And on this slide is an English translation of that case as it's described in the Hebrew Bible. So basically, Exodus presents a situation in which someone mistakenly strikes a pregnant woman and causes her to lose her pregnancy. If the woman herself isn't harmed, the text says that the man who struck her and caused the miscarriage has to pay a fine. But if there's further misfortune, or what the original Hebrew text refers to as ason, and the woman herself dies as a result of the blow, then the case becomes a capital case, a murder case, because again, and again, according to Jewish interpretations of the case, there's a clear difference between the woman and her fetus. If the fetus is expelled, the person responsible gets a fine because the fetus, while it may have value, is not a full living being. Whereas if the mother is killed during this fight, then the man has committed murder because, of course, according to Jewish law, the woman is considered to be a full living being. Now, Catholic traditions tend to understand this very same case in Exodus very differently. In the Hebrew text of the Bible, the word ason in verse 23 it means misfortune. And this tracks in other moments of the Hebrew Bible as well, where the word ason consistently means misfortune. But in the Septuagint, which was the original Greek translation of the Hebrew Bible created in the 3rd century before the Common Era, and which is the basis of the Christian Old Testament, the Septuagint translated the word ason to mean not misfortune, but form, the word form. And because of this difference in translation, early Christian interpretations of Exodus understood verse 23 to be referring not to the pregnant woman herself, but to her fetus. And so early Catholic exegetes, like the 4th century Catholic bishop St. Augustine, understood this text to be making a distinction between a fetus that was developed enough to have a human form and a fetus that was so early on in its development that it couldn't be recognized as having a human form at all. So early Catholic traditions often interpreted this verse to mean that if someone caused the miscarriage of an unformed fetus before the moment of quickening, which is the moment when a pregnant person can feel their fetus move, then it wouldn't be considered murder. But if a person caused a miscarriage of a better developed, formed fetus after the moment of quickening, then that fetus would be considered to be a full living being and its death would be a murder. And in fact, based on this verse from Exodus, Catholic canon law often allowed early abortions before the moment of quickening until 1869. So even in Catholic traditions, a blanket prohibition on abortion is a relatively new invention. And early abortions, again, off and on, were often allowed by Catholic authorities until the late 19th century. Meanwhile, most evangelical Protestant leaders don't even consider this Exodus verse when they claim that the Bible is anti-abortion. And instead, they usually turn to poetic language, like in Psalms 139:13, when the psalmist says that God knit me together in my mother's womb, or Jeremiah 1:5, in which God says, before I formed you in the womb, I knew you. But Jewish traditions, the rabbinic traditions, consider these verses to be poetic. They are metaphorical. The Jewish rabbinical tradition does not give these verses any legal weight. And the rabbinical thinkers who were thinking about abortion never took these particular verses into consideration when determining when an abortion might be necessary according to Jewish law. Okay. So basically, what should be clear to all of you at this point is that Jewish traditions about abortion start from an entirely different premise than Christian traditions about abortion. There is no single Judeo-Christian tradition on this issue, and there is no single Christian tradition on this issue. And anyone who makes this claim is speaking out of ignorance. Following from Exodus, most Jewish legal texts do not consider a fetus to be a life independent of its mother's life, at least the way that they were interpreted by Jewish lawyers in the 80s, 70s, 80s, and 90s. The 6 books of the Mishnah were the very first written books of Jewish law compiled in the 1st and 2nd centuries of the Common Era. And the Mishnaic texts tended to prioritize the life of a pregnant woman over the life of her fetus. So the Mishnah Ohalot 7:6 says that a person must destroy a fetus that threatens the life of its mother until the moment of birth, at which point the fetus would become a baby and its life would be as sacred as its mother's life. And many rabbis since have interpreted this principle to mean that even if the threat to a pregnant person is psychological, and she's not actually in physical danger, that she's still permitted and perhaps even required to terminate her pregnancy. Okay, let's move on now to the text of the Babylonian Talmud, the main text of Jewish law. This is a massive compendium of 63 volumes compiled in late antiquity in the region now known as modern-day Iraq, compiled between the 3rd and 6th century. And the Babylonian Talmud says in 2 different places, Tractate Hulin 58a, Gittin 23b, that a fetus is its mother's thigh, which is another way of saying that it's part of its mother's body with no independent life of its own. One Talmudic authority in Yevamot 69b says that until 40 days of gestation, a fetus is nothing but mere water. So there's a fairly long-standing and quite ancient Jewish legal tradition to prioritize a pregnant person's life and needs when it comes to the issue of abortion. And what's even more salient, at least according to the history that I am doing, is that these are the sources that American Jewish lawyers drew upon when they were articulating Jewish investment in abortion rights. However, you should know, because nothing is as straightforward as it could be in classical Jewish texts, that there is also a strand of Jewish law that is much more restrictive on the issue of abortion. And this is because of the 12th century scholar Maimonides. Maimonides, full name was Moses ben Maimon, lived from the years 1138 to 1204. He was born in Cordoba, present-day Spain, during the Almoravid Empire. Later in his life, he served as a philosopher, a physician, and a practitioner of Jewish law in Egypt and Morocco. And to this day, he is still considered to be a preeminent authority on Jewish law. And yes, that is the joke you think it is. Maimonides said that an abortion is required in a case where a pregnant woman's life is in danger, because in that case, the fetus would be like a pursuer who is trying to kill its mother. And terminating the pregnancy, he said, would be an act of self-defense. This actually contradicts the Mishnah and the Talmud. Because according to Jewish law, a pursuer, somebody who's trying to murder somebody else, is not mere water. It's not part of a mother's thigh. A pursuer is a human being. So by referring to the fetus as a pursuer, Maimonides implied that the fetus is a full human being and that a fetus can only be destroyed if it is directly threatening the life of its mother and not for any other reason. So over the centuries, there have been many rabbis who have said that when Maimonides called the fetus a pursuer, he was just using metaphoric, poetic language and he didn't mean for it to have any legal weight, because then Maimonides would be contradicting the Mishnah and the Talmud, and Maimonides did not have the authority to contradict the Mishnah. He only interpreted it. But on the other hand, there have also been some rabbis, generally from more right-wing or Orthodox Jewish denominations, who have followed Maimonides on this issue. And these rabbis tend to have a stricter version or a stricter view of abortion, and say that abortion is required in Jewish law, but only in cases when a pregnant person's life is in actual physical danger, but prohibited in cases when a pregnancy, say, would cause mental or psychological distress. So basically, what this means is that today all Jewish religious leaders, from the most liberal to the most orthodox, I'm not saying to the most conservative, because in Jewish denominations that has something different meaning, but all Jewish religious leaders agree that Jewish law requires an abortion in cases when a pregnancy is life-threatening. This is a consensus. But there are a minority of Jewish leaders who believe that this is the only case in which an abortion would be permitted according to Jewish law. There are a number of things, again, that we should be absolutely clear on at this point. First, is that no matter where a particular Jewish leader falls or fell on the spectrum of whether or not an abortion can be permitted in most cases or just a few cases, the way that Jewish leaders come to this conclusion is very different than how Christian leaders might even arrive at that exact same conclusion, right? And this makes sense, because we are dealing with religious traditions that developed in very different ways over thousands of years. There is no singular Judeo-Christian tradition. If you are going to remember one thing and one thing only at the end of the talk, please remember that. And the second thing that should be clear is that there is a long-standing Jewish imperative, Jewish religious imperative, to put the well-being of a pregnant person before the well-being of a fetus. and to consider an abortion to be an ethical, a religious, and perhaps even a necessary act if a pregnancy threatens the well-being of the person carrying it. Finally, you should know that most American Jews who make reproductive decisions probably don't really care one way or another what classical Jewish texts or Jewish law have to say about the procedure, right? Most American Jews today and during the Roe era that I study identify with liberal denominations of Judaism that do not necessarily see Jewish law as binding, or if they do, perhaps have a more elastic way of thinking about Jewish law. And instead, these Jews are usually inspired by the Jewish ethics and Jewish values that underlie or inspire Jewish law, rather than going through the entire halachic process. So for instance, and here I'm quoting Rabbi Danya Ruttenberg, who is a prominent activist for reproductive freedom. There's a principle in the Jewish tradition called pikuach nefesh, or preserving life. And the principle here is that saving human lives is the most important thing that a Jewish person could possibly do. And it's a value that overrides any other Jewish imperative. And this is the reason, for instance, that many very observant Jewish doctors who might not otherwise work on the Jewish Sabbath might still be on call for their patients, right? Because the principle of preserving life is the most important value. And so according to Rabbi Ruttenberg, legal access to abortion has to be a Jewish religious value because people who lack access to reproductive health care are more likely to live in dire poverty, more likely to stay in abusive relationships, and more likely to subject themselves to unsafe and life-threatening medical procedures as they seek to terminate their pregnancies. So again, what she points out is that lacking abortion care, lacking reproductive care is something that puts people into life-threatening situations. So it is a matter of preserving life and a Jewish value to make sure that this care is available. So back in the 1970s and 80s, the lawyers of the American Jewish Congress drew on all of these Jewish traditions and ways of thinking when they began arguing that abortion needed to be protected, not only as a matter of privacy, but as a First Amendment right. So now I'm going to take you through some of that legal history. As some of you know, American Jews have a long history of engagement with the First Amendment. And for those of you who might need a refresher on the Bill of Rights, and who doesn't? We all need a refresher, right? The First Amendment promises religious freedom through two mechanisms. First, the Establishment Clause guarantees that American law cannot prefer one religion over another. And second, the Free Exercise Clause blocks any law that would make it impossible or difficult for American citizens to freely practice their religion. In the middle of the 20th century, and in particular from the 1940s through the 1960s, the lawyers who represented the American Jewish organizations, and particularly the American Jewish Congress, were some of the strongest advocates for a very strict interpretation of the Establishment Clause, which meant that they advocated for an absolute separation between church and state. And they argued that American Jews would fare best in a nation that was entirely secular and free of religious influence. Now, this was somewhat of an odd position for Jewish leaders to take, because American Jews generally, at the time, thought of themselves as a religious group. So on some level, advocating for a strict separation of church and state seemed to undermine American Jews' own ability to influence public policy as religious citizens of the United States. But Jewish lawyers adopted this strategy because they were very aware of their lack of power in relation to the Christian majority. They understood that in American law, religion most often meant Christianity. And so from their perspective, any religious influence in American law would not result in shared power and religious pluralism, but rather in coercive forms of Christianity. And of course, they often witnessed this this very coercion in practice. For instance, when Jewish children in American public schools were required to say the Lord's Prayer and to participate in Christmas pageants. The lawyers of the American Jewish Congress were at the forefront of fighting for the separation between church and state. Their legal arm, which was called the Commission on Law and Social Action, was founded and led by Leo Pfeffer, a First Amendment expert who successfully litigated many establishment cases relating to prayer in public schools, state aid to parochial schools, and religious symbols on public property. And he was very influential in making it illegal, for instance, for US courtrooms to hang crosses on their walls or to force, or for public schools to force children to say the Lord's Prayer. So not surprisingly, when Pfeffer and the American Jewish Congress first tried to protect abortion rights, they approached it as a church and state issue, an establishment clause issue. And in 1976, Congress was debating the first Hyde Amendment, which prevented public health care programs like Medicaid from funding abortions. And when the House of Representatives was debating passing this amendment, they consulted with Leo Pfeffer. And Pfeffer told them that, from his perspective, the Hyde Amendment was unconstitutional because it violated the Establishment Clause by embedding Christian ideas into US law. The Hyde Amendment, as some of you may know, passed in spite of these objections. But the question of whether the amendment violated the separation of church and state was hotly debated in the press, particularly once the Supreme Court decided to test the viability of the Hyde Amendment in the Harris versus McRae case of 1980. Anti-abortion activists from the Christian right pointed out that American laws often aligned with religious principles, such as those laws preventing murder and theft, which were also, of course, part of the Ten Commandments. And these Christian right activists feared that if the court decided that the Hyde Amendment was unconstitutional on the grounds that it established religion, that it would then undermine the ability of all religious Americans to ever wield any influence in the public sphere. And this concern gave some Jewish leaders pause. Even those who were strongly in favor of legal abortion wondered what impact the Harris-McRae decision might have on the ability of American Jews to advocate for their own interests as religious Americans. Some specifically wondered whether US aid to Israel, to give one instance, could be declared unconstitutional, given a very strict interpretation of the Establishment Clause. So in 1980, the American Jewish Congress brought this question of whether abortion restrictions violated the Establishment Clause to their Commission on Law and Social Action. And I should say that the brilliance of this commission in 1980 was something to behold. It was made up of some of the most remarkable legal minds of the late 20th century. And among those who considered this question were family court judge Nanette Dembens, civil liberties lawyer Harriet Pollack, the renowned reproductive rights lawyer Harriet Pilpel, and none other than the notorious Ruth Bader Ginsburg, who was then a professor at Columbia Law School. And I have to say that looking through the records of these meetings was just a rare treat for me as a historian. Ginsburg's role in this discussion was particularly fascinating to me. She didn't actually take a position on whether the American Jewish Congress should be using the Establishment Clause on abortion cases. She just kind of spent her time poking holes into everybody else's argument in a really kind of brilliant and devious way. But what Pollack and Pilpel argued was that the American Jewish Congress didn't even need to run the risk of litigating for abortion rights through the Establishment Clause of the First Amendment, because they could throw their weight behind the implied right to privacy found in the 14th Amendment, which was how the Supreme Court argued Roe v. Wade in the first place. And it would make sense that Harriet Pilpel would argue this, because one of Harriet Pilpel's many claims to fame is that she was actually one of the architects of the successful legal strategy that secured the right to birth control and later abortion by drawing on the 14th Amendment and its presumed right to privacy. In any case, what ended up happening was that between 1979 and 1980, most major American Jewish organizations, including the American Jewish Congress over the serious consternation of Leo Pfeffer, who was very upset that this happened, they decided that they would no longer argue against abortion restrictions on the grounds that they established Christianity into Jewish law. They would no longer use the Establishment Clause. And then the following June, the Supreme Court opinion in Harris versus McRae explicitly rejected the idea that abortion restrictions violated the Establishment Clause. So at least at this point in time, this argument was dead in the water. But in 1989, when the Supreme Court tested yet another set of abortion restrictions in Webster versus Reproductive Health Services, the lawyers of the American Jewish Congress, in coalition with other liberal religious groups, developed a different argument for abortion access that was based not on the Establishment Clause of the First Amendment, but rather on the Free Exercise Clause of the First Amendment. And just to refresh your memory, again, the Free Exercise Clause guarantees that American law will not prevent American citizens from freely practicing their religion. And they worked with Harvard law professor Martha Minow, another incredible Jewish woman lawyer, to submit an amicus brief arguing that abortion restrictions prevented not only Jews, but many other religious and ethical American citizens, so she included non-religious ethics in this, from turning to their own ethical and religious conscience when deciding whether or not to terminate a pregnancy. The Supreme Court justices in 1989 did not address this free exercise challenge during the Webster case. They completely ignored it. And to this day, the Supreme Court has never explicitly addressed the issue of whether religious exemptions can be made to guarantee access to abortion. So legally, this First Amendment approach ended up being something of a dead end in terms of late 20th century reproductive rights during the Roe, or reproductive rights during the Roe era. That being said, this approach to the First Amendment represented a real change in terms of liberal Jewish political strategy. For decades, liberal American Jews had argued that their interests as a religious community, or as a religious minority, I should say, depended on the separation of church and state and a secular public sphere free from any and all religious influence. But to gain leverage on the abortion issue, they insisted that American law ought to accommodate Jewish religious traditions that permitted abortion or even required abortion. And they began to insist on their rights as religious citizens. This strategy signaled a certain amount of confidence on the part of liberal American Jews that judges and lawmakers would take their moral authority as seriously as they took the moral authority of conservative Christians. Essentially, liberal American Jews decided to place their trust in an ideal of religious pluralism that offered all religious groups, and I would even say all people of conscience, they didn't only limit it to religious groups, equal access to influence and power. But the fact that this strategy did not succeed suggests that liberal Jews and conservative Christians were not competing on an equal playing field in the debates over reproductive rights. And the fact that abortion access has only grown more restrictive as the 21st century continued shows that perhaps nothing much has changed in this regard, and that the privilege of conservative Christians remains alive and well in the American legal and political sphere. So on that sobering note, let me just answer the question that I imagine at least some of you might be thinking, which is, why do I care about all of this legal history from half a century ago? Why am I spending my time deep in the dusty archives of the American Jewish Congress? And I can tell you that they are dusty, and I'm allergic to dust. It is not easy. Why do I keep thinking about this failed legal strategy? And it was a failed legal strategy to secure reproductive rights. The reason for this is because these late 20th century legal arguments are still every bit as relevant as they were back in the 80s, if not more so. The current Supreme Court, especially since the installation of Judge Amy Coney Barrett, has been remarkably supportive of the free exercise clause of the First Amendment and has been granting nearly all of the claims based on the free exercise of religion. Of course, most of these claims were on behalf of conservative Christians, but still, right? The scholars at the Law, Rights, and Religion Project at Columbia Law School have actually argued that the court's recent opinions have, and this is a quote, created a hierarchy of constitutional rights with religious rights at the top. So the question that many legal scholars have now is, has the Supreme Court backed itself into a corner? Because now that Roe v. Wade has been overturned and abortion is no longer guaranteed in the US under the 14th Amendment, state courts are trying to figure out if there are other laws, other amendments, perhaps the First Amendment, that could guarantee abortion rights. For instance, there's a case, as we know, pending in Indiana in which a number of religious plaintiffs, one of whom at least was here before, one of whom was here in this room, are arguing that Indiana's abortion restrictions are a violation of their religious rights under the protections of the state's Religious Freedom Restoration Act, a state law that builds on the protections of the Free Exercise Amendment. And one of the reasons I'm following this case closely is because I was part of a group of religious historians, another one of whom, who is also, I think, in this room, who submitted an amicus brief to the court demonstrating that the plaintiffs' concerns about their religious rights on this issue were sincere and real. Time will only tell whether a case like this will eventually go to the Supreme Court. At this point, it's probably better if it doesn't. But again, if it does, the justices will have to explicitly address the question of whether Jews have a First Amendment right to terminate a pregnancy based on the Free Exercise Clause. And if the court denies Jews that right, which they probably will, even after granting Christians nearly all of their recent First Amendment claims, it's going to force the American public to really consider what religious freedom means in America, and if the guarantees of the First Amendment ever apply to non-Christians or to anyone with a uterus. When these cases move through the courts, I want the legal actors and political actors and lawmakers who are fighting for abortion rights to be very aware that American Jews have spent the last 40 years fighting for a model of religious freedom that includes every person's right to turn to her own religious conscience when deciding whether or not to terminate a pregnancy. And I want them to be able to draw on those 40 years of legal experience to make their own arguments stronger. So this research is my offering to the lawyers and the activists and the feminist lawmakers who are on the front lines of that fight. I am not a litigator. I am not a lawmaker. I'm a very good researcher. And this is my contribution. This is what I can offer. And finally, I am inspired by Ruth Bader Ginsburg's hope that dissenting opinions can speak to a future age, and that arguments that were once overlooked may someday hold sway. As we know, the Jewish lawyers and activists who used the First Amendment to fight for abortion rights didn't gain much traction back in the 70s, the 80s, 90s. And I can't say that I'm all that hopeful that they will be effective in the current climate. But I am hopeful that their arguments might be revived, maybe taken more seriously, and maybe tweaked, maybe improved upon, right? One day in a new legal era, perhaps at the very moment when we might need them most. But we can only resuscitate these arguments if we know about them, and we can only learn from these arguments if we understand why and how they failed the first time around. Thank you. I don't necessarily focus on them in my work. My book is specifically about liberal Jews who are fighting for abortion access. But they were there, and something that does come up, which is very interesting, is that behind the scenes, members of Agudath Israel, which is an ultra-Orthodox advocacy group, we're often working with anti-abortion Christians to get them to temper their demands a little bit and to say, wait. We know you don't want abortions, but like, if it's for saving a pregnant person's life, we need an exception there, right? So even though, they were fighting for abortions to only be legal in the case where a pregnant person's life was in danger, they were, at least during this period, they were pretty adamant about that and working to make sure that those exceptions were part of the demands of the religious right, even during this time period. The question was, what were the views for I guess those rabbis who only believed that abortion was required in a case where a pregnant person's life was in danger? What were their views on rape and incest? And I'm going to say that it depends on the rabbi, right? It was very, and it is very common, and there's been writing about this, not that I've done, this isn't, again, like I said, I'm really writing the history of Jews who fought for reproductive access. But we have writing and testimonies from Orthodox women who have, in consultation with their rabbis, have secured abortions for a variety of reasons. So it really would depend on the particular rabbi. There is no, as far as I know, there is no official statement on that from at least any of the sources that I've read. The argument that Mr. Travis was making was that the idea that life begins at conception is a theological argument. And as a matter of fact, it's kind of there's no theological agreement on it. There are many theological arguments that have different ideas about when life begins. But since it is a theological argument and not a scientific argument, how is it possible that lawmakers don't always find this, or courts don't always find this unconstitutional? And my answer to that is, I wish I knew. I mean, that's the issue of, from my perspective, of course that violates the Establishment Clause. But this is exactly the kind of arguments that are happening in the courts. So the question was that what was the concern or the argument against free exercise accommodations for abortion care in the late 20th century? And the answer is that the court never addressed it. So, yeah, the amicus briefs were bringing this up, and the court just did not address it one way or the other. And I can't tell you why. This happens sometimes, right? Like, the Supreme Court doesn't necessarily address every challenge that's brought up in an amicus brief. But this seems like a very purposeful maybe elision. And I don't know if the point was to leave this question open. I'm really not sure. The question is that free exercise laws have mostly served conservative Christians, really since the 90s, which is when they, at least the Religious Freedom Restoration Acts were enacted. And do you think it's possible? Is that the question? Do you think it's possible that they can be used to increase or protect abortion access? And again, if they go to this particular Supreme Court at this moment in time, probably they won't be. And that was my point at the end, that if they turn down the religious free exercise claims of liberal Jews, say, to be able to, while basically granting every single free exercise claim that conservative Christians brought to them, then it's going to force a real reckoning, I think, in this country of what is the First Amendment, who does it protect, is it selective? Now, whether these free exercise claims are going to work on the state level is an open question. And that's why we're following all these cases in Florida and in Indiana to find out, okay, is this as a state-by-state strategy for states that have both abortion bans and RFRA laws, Religious Freedom Restoration Act laws, will religious people be able to use free exercise in those cases to expand abortion access? And we'll see. So the question is that back in the late 20th century, it was the American Jewish Congress who was doing this work. Who is doing the work now? So the American Jewish Congress had a very sad, I don't know if I should really say demise, but at this point, as far as I can tell, they're mostly a website. But because of, they lost a lot of their funding in the late 90s and had to dismantle pretty much the entire organization, including their Commission on Law and Social Action, which was really, I mean, where some of the most inventive and interesting legal arguments regarding First Amendment law were developed and disseminated. So I think the loss of that group is something that the current American Jewish community has never gotten over. Today, I would argue that certainly the most interesting advocacy or the most effective advocacy and educational work is coming out of the National Council of Jewish Women. They do have a legal arm, but from what I understand, that legal arm is not what the American Jewish Congress Commission on Law was, in terms of just the weight of who was involved and the esteem that they were held in. I also want to say that a lot of really interesting First Amendment and reproductive law work is now coming out of the universities. So, the Columbia Center on Law and Legal Action that I referenced before is doing a lot of work on this. I've been in touch with them. Micah Schwartzman at the University of Virginia is doing a lot of really important work on First Amendment law. So the work is still being done. I don't know if it's, at least not in the same way, it's not necessarily coming out of Jewish communal organizations. Yeah, the question is has there ever been an attempt for the Jewish community to partner with Muslims on this issue because Muslim religious law also has, if I'm remembering correctly, there's one school that allows for abortion with 120 days after conception, another 40 days after conception. And the answer to that is absolutely yes. And to my mind, this is a very smart legal strategy because the larger we can make this religious coalition, I think the stronger argument one might have that this idea that that all religions agree that life begins at conception will be more demonstrably false. Now we know that to be false, but again, there are many Americans and many lawmakers out there who still think that conservative Christian ideas about the origin of life, about abortion, are Judeo-Christian values, right? They are universal, they transcend Christianity. So the larger we can make that coalition, I think the stronger that challenge will be, both in terms of advocacy and I would imagine in terms of litigating, although like I said, I am not a lawyer. Thank you. Thank you. I'm not going to be able to repeat that, but I really appreciated what you had to say. I will also say that because this court has just overturned so much legal precedent and so many past norms, what at least some of my lawyer interlocutors have told me was that they think it might be time to start rethinking the Establishment Clause again. Because if we have a court in which everything is, is free game, they're just like, well, then why not make the better argument? Which I think at least most of the lawyers that I'm in dialogue with think that the establishment route is the better way to secure abortion rights rather than the free exercise route, which can be limiting. I mean, even if it wins in its narrowest case, it would only provide religious exceptions to particular plaintiffs who bring them to the court. An Establishment Clause argument would be the much stronger argument. So these are kind of the conversations that I've been privy to. Really interesting ones, and interesting at least for me to think about in terms of how they relate to the history that I'm looking at. The question is, how do I respond to critiques that arguments that rely on Jewish law to secure abortion access may end up reinforcing patriarchal understandings of women's bodies, may not really provide a kind of liberating notion of bodily autonomy. And my first answer to that is that so much of American law is based on patriarchal notions that do not respect any person's bodily autonomy. So part of my argument is, given the tools that we have and the moment in which we are, we use what we have. Would First Amendment arguments be that much worse than any other pathway we might have to increase abortion access? I'm not a lawyer, but I'm not sure. My second answer to that question is, when I came to this, I was more interested in thinking about really like the thought experiment of what might American Jewish politics look like? What might American Jewish history look like if we put reproductive politics at the center of American Jewish politics, rather than keep it on the periphery, which is where it usually is, in the ways that Jewish historians conceptualize American Jewish history. So again, I was, in some level, I came to this question because I was interested in what it would tell me about American Jews. The idea that this could be an actual viable or even necessary legal strategy is something that I came to much later, and that the fact that my work might have any kind of value for people who are on the front lines of the struggle for abortion care right now is something that I honestly did not consider before Dobbs, but I'm really humbled and really grateful that at least some lawyers are telling me that they're interested in this, and that it might have some use for them, again, as a way to think through some of the arguments that came before, to make their own arguments stronger. And that's really a very humbling place to be.